Hello, and welcome to another episode of the CollabTalk Podcast, where we discuss the convergence of technology, business productivity, and collaboration culture. My guest today is Dr. Michael Meehan, General Counsel and Chief Legal Officer at Howso Incorporated, an AI company specializing in explainable AI. Now, you're going to have to explain that to us, Michael.
Yeah, for sure.
But he's got more than 2 decades. It's close to you've more than 3 decades, right? You've been doing this stuff for a long time.
Almost 3 decades now.
Yeah. But he previously led IP strategy at Google and Uber, combining his legal expertise with a PhD in computer science to drive innovation and competitive positioning. And I should also point out that we worked together at what was then a startup, E2 Open, and went on. And you were involved with the IP for E2 Open that went haywire with patents, filings, and lots of stuff. Yeah. But welcome, Michael.
Yeah, thanks. Thanks for having me. I thought I'd start us out. So,
for folks, the title official, I guess you saw it on this, but we're talking about the need for competitive IP, identifying and protecting innovation. And Michael and I have actually had conversations over the years about different strategies as we've worked together in different projects and did some consulting together 20 plus years ago as well. But it's interesting. I don't think people understand how much of a strategy, what that actually means when using IP as a strategy. So with that.
Yeah, so I thought I'd start out by broadening the lens on intellectual property. We often think in the industry, the high-tech industry, which is where I've spent most of my career. I wrote my first computer program in the 70s. I became a professional computer scientist in the 90s. And over the years, we've really seen the importance of intellectual property grow. And now that I've been a general counsel for the last 6+ years, I have a broader view of where intellectual property fits. And we think about it more traditionally as focused on employees, but it's really quite a bit broader than that. And so I'll just start us off by telling you kind of like how to envision this if you're a company and you want to take your organization's intellectual property kind of to the next level or very seriously, whichever way you want to look at it. So I've been involved in so many organizations like Christian, and many of them we've worked on together. Often I think the best way to think about intellectual property and just the structure of a company is from the M&A or funding diligence perspective. And I call this view, when you're not actually in M&A or when you're not actually in funding diligence, data room ready, right? So the data room ready view is if we had someone who wanted to give us $10 million tomorrow, 100 million, whatever the scale of your company is, we need to be in a position where we can hand all of the documents over and the finances and everything, hand all of those over, and they can bring in their experts and assess how much money they should be giving us, what the valuation is, and all of that. So I try to keep all of my organization's data room ready. And when I join an organization, I do this. And when I'm at an organization, this is how I structure my legal departments, is to keep everything data room ready so that we could get moving in a very quick way.
I have to say that being an information governance guy and constantly find myself lecturing clients, speaking on the topic of IT governance and helping people clean up their data. How few organizations are data room ready? Maybe you could explain what that means. But I mean, because I just look at that and say, if your house is in order, if you have your sensitivity labels, you've got your classification in place. If you understand the importance of the data, where it sits, and can be ready with minimal additional movement to be able to have that IP in a place where you can then discuss that with investors, with the PE firm, with venture capitalists, with, or an M&A situation, few companies are prepared for that.
Yeah, you're ready for that. And the data governance is a great example. So we think about life before GDPR. People didn't pay a lot of attention to data governance before GDPR, at least many organizations didn't. They didn't have any data labels. They couldn't do anything. Now think about post-GDPR. You've got a lot of data labels in place. And now you need to move on to, say, the Digital Services Act. in some of these European acts that are coming up, the EU AI Act. You've done so much of that work already, and you've kept yourself in a good position so that you can more easily take on these new laws. You have to absorb them, you have to understand, you have to put your controls in place, but you have so much of your data already in place, your data labeling already in place, that you're in a good position to take on these new laws. And the same applies across your organization. So some of the things that I do, and I have my legal departments do, in terms of keeping us data room ready, is looking at the intellectual property from a number of, to kind of keep it more intellectual property focused. There's a lot more than this in terms of data room ready, but we wanted to focus today on intellectual property. And so there's kind of like really, a number of aspects, but really three main aspects to intellectual property in an organization. We all think about employees creating new inventions and capturing them with patents. Of course, that applies to trade secrets, that applies to trademarks, that applies to copyrights. All of those are things created by employees. You need to capture them, and we'll get into that quite a bit more. The other area that I think kind of falls by the wayside, at least in terms of intellectual property thought, is the rights with respect to third parties. And these can get very hairy. So there's really two main kinds of third parties that you need to think about in terms of keeping yourself data room ready. And that spans the spectrum from exploratory conversations with potential partners to true collaborations or joint ventures. And that's a whole spectrum. And as someone who's been in tech for a long time, all of these things typically start hopefully under NDA. I mean, put your NDAs in place, but hopefully under NDA at least. But the NDAs NDAs are structured for intellectual property broadcast, not for collaboration. If they're working well, they'll protect my confidential information when I give it to Christian, and protect Christian's confidential information when he gives it to me. There are lots of wrinkles. There's, these unaided memory, if I can memorize everything you did, I'm allowed to use it, that kind of thing. Sometimes those creep into your NDAs, and you should be careful about those. But what they don't really cover is when Christian and I go under NDA, and then we come up with a new idea together. And then who owns that at the end? There's background patent law, but that's pretty complicated. So this is one of the ways that you're trying to keep yourself data room ready, is to keep these things, really think before you sign an NDA. What is it we're going to do? Because if we're going to start to explore something that's more related to a joint venture where both sides may be inventing, then we might want to put a different kind of document together other than just an NDA. You'd want those protections, but that's something that you need in there.
That is a really sticky area. You're right. I mean, here's an example. When you and I come together, we're collaborating on something. You start talking about an idea, which I might already have in development somewhere that I didn't bring up. Like, who's to say whether I took your idea out of that meeting and went and did something versus do I that, share, like all those kinds of things. But if we create something net new by collaborating together, I mean, my thought, like my logical process for that would be like, well, if you define that, maybe it's in a different document and say, hey, the purpose of this, we're partnering, we're collaborating, but is on my effort, on my project. Therefore, anything created, will be mine that we jointly create. You don't have to sign that, don't have to agree to that, step into that. I mean, is that one way to solve that problem, or is it a bit?
Yeah. And what we find is that these are very difficult to negotiate. No one wants to pre-negotiate away rights to something that could be super valuable, right? So that's the background law is that it's actually a legal structure that defines who can be listed on as an inventor on a patent. This is US law. Who can be listed as an inventor? And if you and I both end up being inventors on a patent, we both simultaneously have the right to exclude, which allows us effectively to each license out, but the other one can always undercut the right. So this actually comes up in patent cases quite often. If you find a rogue inventor who never signed an assignment agreement, you can give that person $50K and get out of the patent, get out of your patent litigation. And so the background law isn't structured well to protect you in this situation. NDAs are not structured well to protect you in this situation. So if you're going to end up in a situation where there could be joint invention, you really need to start to think about other types of agreements. And often what you do is you just hold back the conversation a little bit and say, hey, feels like this could be really important to both of us. Maybe we should stop for a second and think about where we are in terms of our legal structure.
One example of this, when I started with Microsoft, I mean, you and I actually had a conversation. This is back in 2006. I brought a bunch of IP in, and I was actually working on something that a potential product that had both a nonprofit and a for-profit stance. And so I'd actually had planned to go and pursue a doctorate. And so that's why the nonprofit portion of that. But I went and had to disclose some descriptions of that and talk about it with Microsoft Legal before signing on as an employee. And they reviewed that and they came back and said, look, we see some potential conflict. Our recommendation is either don't join as an employee or do not do any new development on these ideas. Don't do anything, like be very careful. Don't use work devices, all those kinds of things. In that time, and just hold off on doing that. And so I just put a pause on that idea, which has still not been built. I still think it's a really good idea. And I've talked with a couple teams about developing an MVP and going and, building the product. But that was something, had that conversation. And at the time, Microsoft Legal was called LCA. I don't know what their acronym is now, but I mean, they made those recommendations basically saying, hey, we're going to run into conflict here.
Yeah. And that's another whole aspect to this. I'll jump back to the third party step, but what they were recommending you away from a pivotal case from the Supreme Court, which is called Stanford v. Roche. And it's a little bit different in your case because you don't work for two organizations, but what we end up with is something that's happening a lot more in tech over the last 20 years. This didn't really happen I didn't see it as much in the beginning as we do now, is people actually working on similar projects for more than one organization. And the most common place in my long experience is the hiring of professors. And so we hire professors to work on the absolutely fantastic stuff that they were already working on at their university. We let them stay at the university, and then they have a dual right to assign. And that's the Stanford v. Roche case, which is you have to assign to, let's say, Columbia, and you have to assign to big tech. And both of those hit simultaneously. They're both covered. And so what do you do there? And so you have to pre-negotiate. Very interesting stuff. There's a lot of documentation and often negotiation that's involved with that. But you want to get away from the underlying the same thing that I said for the underlying issue that both of those organizations can claim a right to the intellectual property created by that professor simultaneously, and that's a real issue. Yeah, and it's similar to what happens in a joint venture, except you have employees from two organizations instead of one employee who works for two organizations. But it ends up being quite an issue, as you rightly note. One of the like the phrases that echoes in my mind through the years is a friend of mine said to me back early in my career, when you put smart people in a room, they're going to invent. Right. So that's the issue. And that's why this is a real problem, because you put these people under NDA. One side is saying, here's some of the non-public's way that our product works. Let's see if we can figure out how it helps your organization. The organization says, here's, like the potential customer, here's the proprietary way that our systems work. Let's figure out how these two come together. And then they say, oh, what if your product just did this? And the did this is where it comes in, right? And this is a very common conversation. It's fantastic. It promotes innovation. It moves companies forward. It helps, it helps in everything that we do as a tech industry. But you do have to make sure that you protect yourself with that.
Yeah, it's interesting. Even as a consultant now, doing my fractional work. I mean, I have to I get approached by, again, my background, my experience in the governance space. I've worked with most of the leading ISVs that are in the Microsoft 365 governance space, product companies, but I will never work with direct competitors at the same time, and I'm very
Yeah.
careful with that. Just say, like, I'm sorry, great opportunities, interesting things they're doing, I see what's different. Doesn't matter if I'm fully engaged with a direct competitor, I will not work in that space, so that I have that buffer, so I don't run into any legal jeopardies there, accusations
Yeah.
of taking that. So there's a clear, there's a DMZ in between those,
Yeah,
those
TMZ, exactly.
projects.
Yeah. Yeah, because you gain a lot of knowledge from one competitor that by the nature of competitors would be useful to the other competitor, right? It's a pretty realistic way to look at it.
I don't think that there's a month that goes by that I don't get a phone call or an outreach through LinkedIn from usually like a PE firm that wants to sit down with me for an hour or two and pay me for my time to pick my brain about the vendors that I've worked with. And I'm just like, look, I'm not going to go and do that. One, I mean, it's I'm not going to go and rip that apart. And I want to, again, the integrity that I have with the partners that I have worked with. And again, I am concerned about if I went and had those conversations and my words being captured, that somehow that, I might say something that one of those vendors, that it could hurt them. Or there's products I like, products that I don't like. There's obvious weaknesses, and I've made recommendations that they've not followed, which I think is foolish. But you have those conversations, but I just don't want, from a legal standpoint, to have any room for somebody to come back and be upset about that.
Should have been a lawyer, Christian. Should have been a
Oh,
lawyer.
I tried. I should have done the joint MBA JD and not just the straight MBA. So I just was telling somebody, I almost forgot that I did this, for those out there. Like, I started doing a night school law program, and I was studying for my midterms, but I was doing this a couple months. I started after finishing my MBA, which was almost, it was close to 3 years. I'm like, I can't do this. I was working full time. I had, my 3, almost 4 kids. It started the software company that we ended up selling in 2001. I'm just like, I can't do this anymore. And anyway, so I admire it, but it's I've not gone back to that path. Talking about, using this for competitive advantage. I mean, an interesting thing. I mean, I remember you and I had a conversation around, it must have been like 10 years ago or more, where we talked about some of the, at the time you were very passionate about some of the needed changes in patent law and the way they look at it. And I know there's been a lot of conversations around that. How has that shifted? Has that changed around how companies are looking at using IP for competitive advantage?
I think that there was a sea change. I don't know if I'm going to be able to put a real date on it, but around 10 years ago, it's very interesting. There was a sea change in how patents in particular work, right? So we haven't talked much trade secret, keep it secret, don't ever tell anybody. Coke is a great example. I'll just do a real quick run through of the IP landscape before getting into patents. The formula for Coke, most famous trade secrets in history. It tastes awesome. No one knows what's in it. No one can recreate it. That's trade secret at its finest. And you can do it in every field. You want to watch out if, you can't have trade secret and open source it, right? For example, right? That doesn't work, because you put it out there. It's not a trade secret anymore. You can protect it with your open source license, but it's not protected by trade secret. There's copyright, which is copying of the exact thing. And that generally is more for music and books and movies. And it's not the broad protection that a trade secret can have, and it's not the broad protection that a patent can have. There's trademarks and service marks, which are, you have lots of great ones. Ray-Ban is a fantastic brand that's they're really focused on that brand and protecting that brand because it is so powerful and so well loved. Then you get to patents, which protect the right to, it's a right to exclude a certain bit of functionality, or there are design patents, a certain bit of design. Design patents are very powerful. The rounded corners, Apple v. Samsung, very famous case from 10 or so years ago. Really fascinating stuff.
The process patent, was that like manufacturing process, that kind of stuff? Or
no, that was a design. Well, one of the critical ones was a design patent. And design patents, hey, for you out there, if you have something cool in your design that you like and you want to stop your competitors, talk to your attorneys about getting a design patent, because they are inexpensive and they are powerful. They're very powerful. And it's basically the look and feel, right? So another great design patent, the telltale shape of that Coke bottle, right? Like they have a design patent on that. It's a very nice shape. It's a very distinct shape. And that's what you have to have, is you have to have some distinction there.
Yeah.
But getting back, you were asking about intellectual property, and I believe there's kind of a whole hour topic here, but there's an underutilization of private information. And that's really, if you go back and read through a lot of the stuff that I've written over the decades, there's just an underutilization, not just in patent law, in a lot of areas of law. And I don't really see patent law changing to utilize private information better to differentiate among patents, but that's not the big change that I want to talk about. But I think that was a conversation we had years ago. The big change that happened about 10 years ago was actually what we're now seeing as what we now see like the next quantum leap with OpenAI. But even before that, there was a pretty big leap in the ability to interpret what is in a patent. And we started to develop, myself included, right? So we started to develop AI systems that could find similar patents. And that's really important, because it used to be the game that, I'm not going to say which few big corps, Christian may have worked for one of them, and there may be others. They would just come with 10,000 patents and say, you infringe, I guarantee you infringe a bunch of these. And nobody.
I would say the worst were these companies that, again, it was like 10, 15 years ago, that was like in the news that they would go in and swoop in and buy these patents to do nothing more than to go and prosecute.
Oh yeah, the patent troll problem was, that was actually a big sea change. There was a patent case that came out that made it difficult for non-practicing entities to get an injunction. One of the hardest things to overcome as an operating company, one of the most dangerous things that can happen in a patent case is not the damages. It's not the $100,000 in damages. That's a fixed cost. You appeal it, maybe it goes up, maybe it goes down. The bigger problem is if you can't operate, and that injunction is potentially very damaging. And so there was a change from the Supreme Court that disallowed non-practicing entities from getting injunctions because they themselves don't practice. Competitors can still get them, and it makes a lot more sense, right?
Like that makes total sense.
It is a right to exclude, but monetary compensation should be fine for non-practicing entities. They shouldn't be able to just stop, they shouldn't be able to stop every self-driving car from operating on the road. That's not what the patent system is about. It's not about stopping innovation. It's about promoting innovation. And so you want, if there's one company that's inventing all this stuff and they need to proceed and they need to stop their competitors, great. That's still allowed under the law, but non-practicing entities can't shut down an industry.
So I see how that would impact those companies, that was part of their strategy. And I'm not saying anything against that. I mean, because through merger and acquisition, they might be doing it to eventually, they own a huge patent portfolio. They may incorporate aspects, but there's that time where they are a non-practicing, a company where they've not yet incorporated that in.
I think generally those companies, the ones who were doing broad enforcement, they were typically not practicing anything except patent law.
I mean, have
Right?
those gone away? Are there still companies that are doing
They
that?
still exist. There are far fewer than there used to be, or there are far fewer cases, I should say, than there used to be. I think that was very big business when they could get injunctions, and it's far less now.
Yeah, it's interesting again around this. I mean, one of the key things that I understood about patents versus trade secrets too is that yes, if you go with that to show that advantage, one, it's limited windows. So if you don't have the funds to go and manufacture, go to market with that and take advantage of that time period, it's limited. When that window is shut, then anybody goes in, they've got all that information, they can go after you. But the so obviously that's a decision you have to make. I mean, do you see companies, is there a movement one way or another around going with keeping it trade secrets, going after formal protections?
Well, it's very different per industry. So the pharmaceutical industry operates on patents, right? It's probably, it's one of the most important tools that they have. And that's what you're talking about, going after them after the period's over. That is the existence of generics, right? So generics are things that are created after the patent terms are over in the pharmaceutical industry. We in the tech industry, by the time the patent is, out of its range, often that's not what the market is doing anymore, right? So I do a lot of work with organizations in catching up when they're behind in intellectual property, and one of the ways you do that is purchasing patents. And the sweet spot is typically about a 10-year-old patent. At 10 years old, the product is in the market, it's very strong, and you aren't that close to the expiration of the patent, right? So often at 10 years from initial invention, it takes a few years to get the products out. You're in a pretty good spot in terms of patents. Sometimes you're visibly there at 5 years, but by the time you get to 20 years, not only are you nearing the end of the patent term, but that's less likely to be something that people are actually doing anymore. Like think about what we were working on 20 years ago. Not that much of it still exists, right? It's just not around.
Although I always like to point out that the interface that we developed for E2Open's collaboration manager stuck around. It looked pretty much the same for about 15 years. It was a great product. Like the interface for it was very strong.
Yeah, great product.
It was a proud moment. It was a good product.
Yeah, it's a good product for sure.
It's funny. I always tell the story of I wrote a white paper in 2004. So when you and I were doing projects together and working together about SharePoint and how it was garbage back in 2004, I got invited up to Microsoft campus and talked to the product team, and they're like, look at what we're doing. And they were working on, and you probably don't know the versions of it. They were working on what was live was the SharePoint 2003, and they were working on the 2007 version. And they showed it to me, and I was up in Redmond. I'm like, guys, this is junk. And then I showed them what we had done at E2Open, and except the entry point for what we built was like $1 million to get started, and it was very, very expensive in comparison where they were trying to build for the mainstream. But no, it's it's interesting again, talking about from a strategy standpoint. Some companies like, hey, there's one Reveal It that we both are advisors for and investors in, and where it was the patent strategy. And part of that I look at, and as they've been landing patents and doing a lot of great innovation, you almost have to be noticed in an industry where you're really going against massive companies, massive players. Trade secrets is probably not the right, the right strategy for that. You need to do something that stirs things up and gets attention.
Yeah. Patents are a great backstop to value, right? So I talk to a lot of venture capital venture capitalists. And some of them actually see these, not only do these patents kind of like get their attention because it proves, it's a third party source saying, yeah, there's innovation here, right? It's a government organization whose job it is to figure out.
It's a novel, right? Yep.
Yeah. Is it, is this something new? And that in itself has quite a bit of value. But they also see it, right? There's a market for intellectual property. There's a market for suing people. There's a market for purchasing patents, which I'm often in the purchasing patents market. The venture capital folks, they're often like, well, I think this company is going to go forward. And if not, they've got this great patent portfolio. We're going to get some backstop value here. Right. And not only that, but for companies like Reveal It and others that have these great innovations, they're small potatoes, right? Like they don't have this big organization, and a big company could see what Reveal It's doing once they start getting some traction and say, we're going to do exactly that same thing, right? And just copy it and just throw 600 engineers at it for a year and build a pretty good product. And so what companies have when they have a patent portfolio, especially a patent portfolio more than anything else, is they have an ability to go after that company and say, hey, here's our litigation brief, right? You copied all of our features. This is what it's going to look like. Let's talk about you buying us, licensing our IP, or we're going to court, right? Like something's going to happen. And that is a great backstop for a small company to be able to go after a market and not worry quite as much about the big guys. I mean, it's a hassle to go through patent litigation. It takes a long time. It's very expensive. If you're a really small company, you might have to get a contingency firm so they get a bunch of the money if you win. All of these things are things to think about. But it's something, because if you go and do all of these cool, new, innovative things and you don't protect them with patents, copyrights, trademarks, and all of the things that you have available to you, then when the big company comes in, you can't just say, hey, I did it first. That's not how IP law works. Hey, I did it first, unless they stole your trade secret, infringe your patent, your copyright, or your trademark, you don't really have a leg to stand on.
That's the hard part for, I think, people to understand is, how do you prevent competitors from exploiting, what you view as proprietary that you've gone in, let's say you have, a design patent in place for this or whatever it is, you've got protections in place. Again, I go back to that fundamental thing. It's like, it's great that you have these, but if you don't have the money, the ability to go and defend that, then you don't have anything. And you can be bulldozed. Yeah,
you can. Yeah, and you have to look for third parties to help you out sometimes, right? So contingency firms, whatever it is, it's some sort of organization that can help you out if you don't quite have the money to go after. But you have to have a pretty good case too, right? The contingency firm is they're not going to take a case where they think they have a 10% chance of winning. They're going to take a case where they think they have a 90% chance of winning, because they're like, well, we have to get paid. I have to feed my kids too, right? Like that's basically
and that's why if you've got the dollars, if they're like, hey, there's like a 60 to 70% chance of winning this, but we've got a full bank account, we can pay the attorneys to do this, then sure. But otherwise the smaller player, Well, so when you go in and you work with companies, I know you've worked with, going in, I remember visiting you when you were at Google. I think it was still early your time there. I just remember going over to the campus and, but I think it was my one time visiting the campus over there. But when you go in, like, how much do you have to with these larger organizations have to help them get organized around their IP strategy, or was it already set and you kind of adopted that? And what can small companies learn from that of establishing a strategy around?
It's pretty similar between big and small companies in terms of establishing a strategy. I would say that Google was in very good shape. It had a lot of fantastic people at it already. And
I've heard that they have good people there. Yes.
Yeah. It was disorganized though. It was very disorganized. They were not data room ready. right? So I remember, I can't go into specifics, but I remember some things that I was like, wow, so we don't have a tool for that yet. Okay, cool, good to know. But
no,
we built
again, that's why I said, having worked with large and small companies in the information management space, very few, rare to find a company that is data room ready.
Yeah. And the reason data room ready really sticks in my head, I've done a lot of purchasing of companies. Mm-hmm. So I've been involved in a lot of M&A, and often it's M&A where intellectual property is the thing we're buying, right? So we're buying the people and we're buying the thoughts in their heads and the software that they wrote, right? So those are right? So we're hiring the people. We don't care so much about their customers. We don't care so much about, the interface. It's really this underlying technology. And so I've seen the full spectrum of, I've seen it from, a contractor wrote that important piece of our software. It's like, all right, well, please send me the contract that you have with the contractor. Oh, we don't have a contract with it. And I was like, oh, why? Here's a landmine for us to discuss in a meeting when you're not here, right? And so like there's a lot of complicated, it goes all the way from that to another company that I worked with which I was just talking about them. I was just talking with people from there just a week ago or so. And I was like, I remember when we brought you in, when we bought your company back in the Google days. And he's like, oh yeah, it's great. We didn't interact with you much. I was like, I didn't need to. You guys were in fantastic shape, right? Like you had everything in place. You had good processes and all of that. And so the lessons work from the littlest company to the biggest companies that I advised. I worked with a pretty large company that everybody knows. I won't say which one, but they kind of had nothing in place too. So I had to build it all out with them when I worked on it. But it's the same at almost every organization that I go to. And I really like to look at every new organization I join or that I start to advise with that data room ready lens, right? Like, are there contracts in place? Sometimes it is as simple as, where are all of your customer contracts? Oh, they're in some of them are in Jim's email, and others are in Sally's. But Sally left a year ago, so someone still has access to her email, so we can go back there and find them, right? So I'm not saying you have to have ironclad and everything is all the metadata is there, but you need a Google Drive folder or something that holds all of them in place so that you can access them. And it goes back to kind of what you were saying about the data labels. Once something flips and you're like, oh, this customer's not paying, or someone wants to fund us or something, you need to be able to find all that stuff in an instant, right? It should all be there right away. Your intellectual property, your customer contracts, your NDAs, you're going to have problems, and you want to be able to find all this supporting documentation right away.
It's so funny. I had an interview with someone that was in the legal space and was talking about how, before I got into tech, when I was, just before I got married, was working for a law firm in Sacramento. But I learned a lot of lessons because I was responsible for long-term storage and destroying the materials and like doing that, as well as filings at every courthouse, Muni and Superior around Northern California, like all that stuff. But I learned the principles around the handling of case files and why and the impact. I had the lead attorney there, Tony Poidmoyer, who like walked me through and explained why it was so critical around this, and that just stuck with me getting into the IT world and working with data warehousing and the cleanup of data and the organization of that and the maintenance of that data into then information technology, knowledge management systems. It's funny how those principles that are true. I mean, everything that you're talking about, it's like, that's the stuff that I preach around knowledge management, information management, data management every day. It's the same principles around there. And it's a lot of effort to go and clean that stuff up. Now, with the advent of everybody wants to go and implement AI solutions out there, it's like, what are people finding? It's kind of like when you invest in high-end search capabilities around all of your data. What starts happening is you start surfacing data that shouldn't be surfaced in the way that it was surfaced. You start realizing that security through obscurity of this data is not a good strategy, that bad actors are going to find this data. I would say bad actors, people make mistakes. They don't know that if it's not labeled, classified, in the right locations, accessible to the right people, the right systems. Or in your example, it's like I'm sharing stuff in email. I've got a OneDrive, a Google Drive. I'm sharing stuff because our corporate system is so locked down. I need to interact with people outside the company. Yet this is a unsupported platform, a cloud platform that I signed up for. I'm using Box. I'm using whatever it is. I've got a Dropbox, and then I leave the company, and then I've still got IP that belongs to the company in what I paid for personally, and the IT team has no idea. And that stuff happens constantly. And so it's never too late to go in and get those things organized, whether or not you're thinking about mergers and acquisitions or the rest of the IP. It makes sense to develop those processes, healthy management of that data, so that you're more prepared for whatever the strategy that your company has for that IP to go whatever direction.
Yeah. And as a profession, as a legal professional, as a general counsel and chief legal officer, every morning, one of the things I love about this role is every morning I wake up, I open up my email, and I wonder, what crazy thing happened since I last checked my email last night, right? And being data room ready lets me handle those situations. Having my company organized in a way where it's often customers, right? This customer wants to cancel, and I look it up and I'm like, they don't have a right to cancel, right? They have a 3-year contract. And this is actually an invoice, this is not a request to renew. This is an invoice. Those are structurally different things under the eyes of the law. And so, but I can answer that so simply because I have it all organized. I'm ready for that. I'm data room ready, so I can answer that very quickly. And if it becomes complex, and we deal with investors all the time, they want to see everything, right? They don't want just what's the question for this particular customer. Then they're like, I want to see it all. How many of these do you have, and how many of those do you have, right? And it's simple questions when you're organized.
I do want to go back, Michael, and talk about like startups and small businesses. I always like to address kind of the practical application of the topics that we're discussing. Like, how do I actually use this? So what are some practical ways that organizations can develop that IP strategy? If I work in the tech space as well, so it's mostly ISV, independent software companies, and consulting companies, and some MSPs, some learning companies, things like that. But in the IT, the information worker audience space, so what are some things that they should be thinking about as they're developing their strategy?
Yeah, it's a great question, and I think that if it's the simplest, or if it's the only thing that someone remembers out of this, it's really that you need to have a broad view of your entire company and figure out what is your competitive advantage. The problem with a lot of IP strategies, especially for smaller companies, in so much as they even protect anything with anything, it's the squeaky person gets their IP protected and no one else does. And that is not a great strategy, right? So it's the person who's like, I think that a great product name would be this. And you go and file trademarks, but you don't have your company name trademarked, right? Because your strategy is that's the only person that came to me to file a trademark is that one, or a patent, or whatever it is, right? Like, you don't want that. So you need to have a broad view. You need to figure out what your actual differentiation is. It's often product names. It's often company name. It's often those few key areas of invention. And don't worry that you're not a patent attorney. Bring that patent attorney in. The magic of patent attorneys is that they know they can take this is our product is, this part of our product is the most important thing. That's not really what you patent. You patent some aspect of it, some functional aspect of it, some portion of that product or multiple portions of it. So you get that broad view, get in a good patent attorney. They can kind of differentiate it for you and break it down into, you could file these 5 patents, and you rank them or, in these trademarks, and you rank these things, in your own internal system, and the patent attorney or trademark attorney will have like a little bit of magic where they say, this seems more likely to get a patent or trademark. This seems less likely to get a patent or trademark. Kind of combine those two. And then you figure out what your budget is, right? Is your budget $10,000 a year to work on this? Is it $20,000? Is it $100,000? And that's the thing that lets you decide how far down that rank list you go. But the key is having that rank list, because you don't want the squeaky person to just come in, and so you're an
right.
AI company and you have your only patents on a bacon straws, right? It's just
everybody
not going to help you.
Everybody understands, like, you're sitting in a conference room with a dozen people and there's that one really loud person who always seems to get their way because they're just really loud. So it's that squeaky person. You don't want them driving the strategy.
Yeah.
You need to have input from all 12 people. Right.
Yeah. Sometimes it's the quietest ones that are working on the hardest problems, right? So,
and there's sometimes the scariest people.
You want to elicit some of that important information that they're creating out so that you can decide whether you patent it, right? And not everybody patents everything. I've been in organizations where we didn't have infinite budget, but we had a mandate to patent broadly. And then I've been in other organizations where we shrunk the patent budget quite a bit because we already had a lot of patents. I've been in organizations where we shrunk the trademark budget quite a bit and just trademarked one or two kind of key things. So it's, there's lots of ways to do it, but the important thing is to know what's most important to protect first, second, third, fourth. That's the key. That's really the key.
How do you, so working with these clients, so how does an organization know whether, so they prioritize those things, whether that strategy has created really a measurable competitive advantage?
Yeah, it's a good question. It's the world of patent law, the world of law really is a world of alternate realities. So it's actually very difficult to quantify, right? So, you look at an organization like Google, it has won untold legal battles. How do you really quantify that? Well, if you never had any of us there, Google might be a very different company. Maybe it wouldn't. Who really know? Maybe we wouldn't have had all those Supreme Court amicus briefs that helped shape the tech industry, and maybe we wouldn't have had, some of the FTC consent decrees, which effectively become the standards around the industry. You don't really know where things are going to end up, so it's difficult. It's difficult to really quantify it. But to say it another way, if you're protecting your most important innovations, your most important product differentiations, the cost of doing so, I think most who are knowledgeable about these costs, they are expensive. The law is an expensive thing.
Yeah.
But the cost of doing so will almost always, I would imagine always, outweigh the potential damage to your company of not doing it, right? So if you don't trademark your company name and someone else comes in and just, there's common law trademarks, but someone else, kind of stomps on you, then you're kind of lost, right? There's not much you can do, because like we were saying before, if you haven't protected with, under trade secret, patent, copyright, trademark, you don't really have a leg to stand on. So someone could just kind of come and take your lunch, and then you're like, hey, that was my lunch. But you're like, well, you didn't own the lunch because you put it out there, and now we didn't actually take it. We just made our own thing. And yeah.
I think a good parallel is, if you think of, most people are more familiar with, the cost of a data breach. And so nobody wants to do the preventative and spend that money if not necessary. But the bigger it's actually from a cost perspective, the cost of a data breach the impact is so much higher for a small company than it is the larger companies. Yeah. But it's one of those things where most companies don't think about data security until there has been a breach. Yeah. And then they go in and put the policies and things in place. You have to, you don't want to, unlike, maybe you can recuperate your data, you've got a backup of that. There's not that same recourse for lost IP. You could lose everything.
Yeah. The industry is just rife with, I'm not going to go into any of them because I don't want to offend any takers or upset any people who lost it. But the industry is just filled with people who didn't have any rights to intellectual property. And, some bigger corporation with lots of resources was like, yeah, we want to do that. We're going to do that. Right. And there's a lot that you can do as a big organization. And, even if you're infringing somebody's IP, they still have to sue you, right? Yeah. They don't get to just stop you. This still is something that has to go to the courts. So it's a great thing to have, because it's kind of in some cases, it's kind of your only weapon that you're going to end up having at the end of the day. And you're asking about quantifying. One area that hopefully your organizations never end up in, but these are the kinds of organizations that contact me to help them out, is there are some major patent aggressors that are practicing entities in the world. There's probably like 5-10 companies who are the ones who typically go out and enforce their patent portfolios on a more regular basis. And when those companies come calling, if your organization doesn't have a lot of patents of its own, then often what your move is not just to pay the $75 million a year that corporation's asking you for a license to their patent portfolio. No, you go and you hire a bunch of experts like me who will help you build up your patent portfolio so that you can go back to them and say, well, but you infringe a bunch of mine patents. And then it becomes a negotiation instead of just like being held up, you're then negotiating about how much money should flow each way. And that's a way, that is a quantifiable thing that happens where you can say to your CFO or your CEO, yeah, we spent $7 million doing this, but we got an $85 million request down to $2 million. So that's what we're calling a win.
Yeah. Well, so final question for you. I know that we're on close to time here too, but with so much, you've talked about the sea change that has happened, 10 years ago. I mean, looking specifically at how much AI is changing, certainly in the information technology world, do you see the role of IP evolving as well? Is there anything where you see that it's shifting the way things are done again?
Well, I see that the increase in AI and its ability to find important or related, let's call them related patents, has been incredible in actually reducing the number of patents that you need to get. And in dealing with these threats from mega organizations that have tens of thousands of patents, no longer is it this unbelievable task to go through 40,000 patents and say, I don't know which ones we might infringe, so let's just pay them because it's going to cost us so much money just to go through these, and then we still don't really. Then we're just at a more certain maybe, which is all of law is a maybe, right? But yeah, you get to these higher levels of certainty in the maybe, and now I can actually, I wrote systems 10 years ago that allowed me to go out and say, okay, well, here are the 500 most important patents in field X in the world, and you don't have any of them. So I'm not so worried about you. You just take your 40,000 patents and go away, because I don't think you're going to have anything. And if you do, show me and we'll start talking about those one or two. But they often didn't know what patents they had, right? So that was that nobody did. Right? They were just like, don't make us go through this exercise, just give us millions of dollars. So I think that's changed patent law dramatically. And because it's shrunk, it really shrinks the needed portfolio to be very competitive in a marketplace is much smaller now than it used to be. And as a result, they also become more important because everybody actually knows. No longer are they hidden in obscurity.
Yeah,
a good patent, it can be found very easily, and everyone will know, hey, they've got the good patent, they've got the best one, so let's watch out.
What's exciting about this space, again, 20 plus years ago, we were talking about, so I know what my startup we sold that was around pattern recognition, which we're developing an early social graph and the connecting of all the data and then looking at those patterns to be able to find this stuff. Now with AI to do that, lightning quick and find this.
Yeah.
I mean, just from the research standpoint, as well as the patent prosecution standpoint, just it has been a game changer.
Oh yeah. And I mean, honestly, AI, I talk with law firms all the time about this. AI is changing the nature of our practice, right? So we're adapting now to, the biggest concern is training young associates. It used to be that, the young associate working on my M&A or my funding would go through and read 100 contracts and 400 NDAs, and they would know contracts and NDAs really well. They don't need to do that anymore, right? So we need to figure out, are people being trained the right way still? It's possible that they're still just kind of like getting what they need because they no longer need to read those. Or do we need to start, being more proactive in training and not just rely on the underlying work to do that? So it's changing a lot for us.
Well, Michael, I really appreciate your time. I'm not sure we could talk for hours on this, and I have a bunch of other questions that we didn't get to, but it's a fascinating topic, and we'll have to do it again sometime, maybe sometime next year. And
for sure. Yeah, it was great.
It was great talking in 6 months.
Oh yeah. We can. There are lots of topics we could talk about for sure.
Yeah. Well, thanks a lot for your time.
Sure. Take care. Bye.
You've been listening to the CollabTalk Podcast. New episodes are published weekly, and you can find us on Spotify, Apple Podcast, iHeartRadio, and most other podcast platforms. Thanks for listening.